Welcome to Civitas Conversations today with Professor Jonathan Adler, who is now the Taylor Professor of School of Law at William and Mary. Before that, he taught for a number of years at the Case Western Reserve School of Law. He is a widely known, highly esteemed legal professor, particularly in the areas of administrative law, constitutional law, and environmental law. Many will know John blogging at the Vladeck Conspiracy. He has also now joined us here at Civitas as a contributing editor to Civitas Outlook. And we're going to be discussing more in depth today a piece he recently wrote for us called Mistaking Principle for Appeasement, which concerns how the Supreme Court has handled the Trump administration's use of executive power. John, thank you so much for coming on.
It's my pleasure. Good to be here.
John, having recently left Cleveland, the city misses you. Shaker Heights won't be the same without you, obviously. But I know you're now in better climes and near Northern Virginia.
Yes, much warmer here.
Yeah. So thinking about this piece, Mistaking Principle for Appeasement, you argue that a number of critics of the Supreme Court, who are also usually critics, or in many cases, critics of the Trump administration, have argued that the Supreme Court is appeasing the Trump administration, to use one person's words, and allowing it to pretty much get away with dubious uses of executive authority. The administration has made 20 applications for relief from district court or lower court injunctions of its actions, and 17 of those have been granted by the court. And yet you argue it isn't appeasement, it's actually the court trying to be prudent and to think carefully about its powers and the principles of its powers and how it should carefully husband that in the face of the Trump administration. My first question for you is, when we use the word appeasement, is that the way to think about what the court's doing with the Trump administration?
Yeah, I don't think that's a good way to think about it. And in fact, I don't think it's even useful to view this initially in kind of political terms. I think most of those folks that characterize the court as acting in this way think of the court as primarily a political actor and looking at the extent to which the court is willing to push back against the executive branch within the bounds of its own power. And what I think these analyses tend to miss is that we have a court that's a conservative court that is fairly formalist in the way it views the nature of government power, its power and legal rules. And that if one looks at the issues that have been coming before the court, one can see a court that fairly consistently is focused on some pretty bedrock questions about the nature of judicial power, and a court that is suggesting, and in an earlier case that I wrote about in a prior column for Civitas, made explicit, which is, even if one thinks that the executive branch is exceeding the scope of its power, and I think in some cases that's a fair criticism to make of the Trump administration, the answer for that is not for the judiciary to respond in kind. That is to say, a breaking of constitutional bounds does not justify another breaking of constitutional bounds. And I think a better way to understand what the court has been trying to do is to remind lower courts that there are limits to judicial power. There's a proper way to evaluate legal claims against the executive branch, and that concerns or suspicions about the Trump administration's broader political agenda, or whether or not the Trump administration is a good actor in other contexts, shouldn't alter the way that courts do what is their fundamental job, which is resolving disputes that are properly brought before them.
I mean, I think you raised that. It seems to me if you hear someone making the case that the Supreme Court is appeasing the Trump administration, the other side of that has to be there's been very aggressive actions also by federal district courts, right, against the Trump administration, which, not that is the first time that's happened, but it seems that the ongoing nature of that is very aggressive, and is something that is going to raise the stakes in this set of issues.
Well, certainly. I mean, so the Trump administration has been a very aggressive administration in trying to implement its own policy agenda, and the litigation campaign against the Trump administration has been equally aggressive and certainly without precedent. And there are well over 100 cases that have been filed. There are dozens upon dozens of injunctions of various sorts that have been issued against the Trump administration from doing various things. And as I've already noted, in some of those cases, the Trump administration has properly lost the early rounds of those cases. But what I think the court is trying to indicate to lower courts is each of those cases has to be evaluated on its own merits. And insofar as the Trump administration has selectively identified a handful of cases, and in some instances, parts of cases, to bring before the Supreme Court to say, hey, district court overstepped here, the court is policing fairly traditional boundaries on what district courts should be doing. And one sees that against the background of the Trump versus Casa opinion, where the court reminded lower courts that declared that lower courts don't have the authority to issue nationwide injunctions with their reserved equitable powers. The court is saying to district courts that they still have to color within the lines, that not every executive branch overreach necessarily justifies district court action at all. And if it does justify court action, that action must be bounded by the traditional constraints under which district courts operate. So one such constraint is you only provide relief to the parties before the court, and you don't provide relief more broadly than is necessary to give relief to parties before the court. Other constraints that I think are implicated and that I raise in my column are constraints on things like who has standing to sue the administration, and not just assume that states, for example, can always sue. There are other constraints that Congress has enacted. Congress, in the context of employment actions, so reductions in force and things like that at federal agencies, Congress has created a process through which those sorts of claims are supposed to be brought. If you think you've been improperly fired or let go at a federal agency, there is a process for you to go through. It's not go to a district court and enjoin the executive branch from firing anybody. And yet that's what people have done, and that's what some district courts have agreed with. And I think a fairer way of evaluating the Supreme Court is saying, yeah, the executive branch may not be behaving, but we, the judiciary, have to behave too. And some of you district courts are not doing that.
I guess one point you also raise in your piece is that the administration has brought 20 cases. I don't know how many cases it potentially could bring under these injunctions, but they brought 20. You said these are the 20 best, probably from their side, that they have the chance of prevailing on. But one question too is, well, what does it actually look like? What do these cases look like when they come back through on the merits versus everything's coming? This is the emergency docket, and if it comes back through on the merits docket, it seems to be the cases could also look remarkably different, including how the court rules, obviously.
Sure. I mean, so, I think it is fair to be concerned by the fact that a lot of this is happening on what we call the emergency docket or the motions docket or the shadow docket or whatever name we want to give it. We used to call it the shadow docket because it didn't get attention, but clearly that's not an issue anymore. I think there is a concern about the speed with which some of these cases are handled and the fact that therefore the court doesn't have the opportunity and doesn't take the time to write full-length opinions. And I think it's a fair concern. Of course, the problem is in a lot of these cases is district courts are issuing injunctions that take effect right away on the executive branch, preventing the executive branch from doing what the executive branch normally would be allowed to do in terms of administering programs, issuing rules, what have you. And the court is concerned about litigants running out the clock on the presidential administration and just delaying the ability of an administration to do what it was elected to do. And so there's a tension there in the sense that the nature of the orders that are being brought to the Supreme Court require quick action, but quick action by courts is often not the best way for courts to act. And so that's a fair concern. And we could have a debate about whether the Supreme Court is properly balancing the need for dispatch in these sorts of cases with the desire to explain things. In terms of what happens on when these cases go back to district courts, I mean, certainly there a range of things can happen. So in the context of the birthright citizenship litigation, right, the court said no nationwide injunction just because because you think this is a nationwide issue. You have to instead look at the parties before the case and what would give them relief. And the court noted there were two possible ways that the litigants might be justified in getting or seeking what is in effect nationwide relief without just issuing a universal injunction. One is a class action, right? So a class action, say, representing non-citizen parents and pregnant women who are non-citizens whose children will be affected by the order. A nationwide class of those individuals would justify nationwide relief. There is an argument states in this limited case might need nationwide relief because they are affected by people moving in and out of the state in a way that makes it hard for a court to just give relief within a single state. So in some cases like that, when it goes back, all that might happen is district courts actually do the work of making sure the relief they are providing is in fact legally authorized. And the academic in me very much approves of that, right? That is to say, it's not enough that courts get the right result. They need to get it for the right reasons, and they should be explaining what the reasons. But I think there are a lot of other cases where forcing district courts to actually do the work and to consider the proper questions results in these cases going away. One of the cases I wrote about in my column, I think district courts don't properly have jurisdiction over some of these cases. They don't have the authority to consider simply enjoining the federal government from reducing employment in certain federal agencies as an independent matter. And so those cases should go away. And that may mean, and I think this is important to note because it is a feature of our constitutional system. It may mean there are some instances in which the executive branch does something that is illegal and there is no immediate judicial remedy. And it may even mean there are some cases where there is no effective judicial remedy ever. And that's true, right? And the Constitution is not just for the courts. It is not something that is just for the courts to interpret and enforce. It's something that is for all of the branches. Each branch has an independent obligation to conform its conduct to the Constitution. And not every remedy is judicial. You know, we can go all the way back to Marbury versus Madison with the court reminding us that there are cases that present questions that have to be resolved politically. And some of the things the Trump administration is doing that are controversial are the sorts of things that have to be resolved in the political process. And I just highlight that because I think in our political culture today, we're too quick to assume that anytime any governmental actor does something that's unlawful, there has to be a court that can do something about it. And that's actually not true about our constitutional system.
A question that seems an unspoken premise here in this battle between the Supreme Court and the Trump administration is that somehow there's just mass illegality and dubiousness behind what the Trump administration is doing with executive power. How should we think about at this point? We're all, not 7 or 8 months in. This has been an incredibly aggressive administration, I think, descriptively. I think that's true, and everyone would say that. But how should we think about their use of executive power?
I think it's fair to say the administration's been very aggressive and very, focused on particular initiatives. I happen to think that on questions about, illegal, not illegal, and so on, the details matter. And what the administration is doing in different contexts, each question needs to be evaluated independently. And even in an broad area like immigration, right? There's a lot that the administration is doing that Congress has allowed the executive branch to do. There's a lot the administration is doing that prior administrations could have done. There's a lot it's doing that prior administrations should have done and arguably were legally required to do. There are also specific instances where the Trump administration has not been careful enough about the sorts of due process that is required in some cases for certain types of individuals before they can be forcibly removed from the country, or the way that they can be removed. And so even in a context like that, we can't just say, oh, flagrant illegality. We see aggressive executive action. We see some of it which is clearly lawful, some of it which is, arguably defensible, but you kind of playing on the boundaries of what's been established and what hasn't. And then some instances where the administration's been overzealous or not sufficiently concerned about how the law constrains it. I think in that way, though, that's not new. We might think that the brazenness or the aggressiveness of the Trump administration is different, but the willingness to transgress legal boundaries in pursuit of broad political goals was not invented by this administration. If you look at the way the Obama administration implemented the Affordable Care Act, for example, there are multiple instances where the Obama administration adopted, very questionable legal views about what it could do and then let them be litigated. And there are other instances where the Obama administration did things that it knew were illegal, but felt were necessary for the act to be implemented or administered in a way that it thought would be effective. And some of those cases even involved questions that could not be litigated, right? So I think that Trump administration's failure to enforce the TikTok divestiture law is flagrantly unlawful. I think it's an exercise of what we would call the dispensation power that was a royal prerogative that we most certainly did not give our president under our Constitution. But the Obama administration did the same thing with something called the employer mandate penalty under the Affordable Care Act. Right? This was a self-executing tax obligation that the statute created. And the Obama administration just said, not simply they're not going to enforce it, but that they told the private sector, do not comply, and there will be no consequence, which is in effect what the Trump administration did with the TikTok law. So that was bad. I was critical of that. Some other folks were critical of the Obama administration doing that at the time. It's the sort of thing we don't want to happen. But the Republic didn't collapse because of it. We're in a culture where we think the executive branch does something unlawful. A district court issues a bad order and suddenly it's the end of democracy. No, there's a lot of play in the joints of our system, and it's a system that is implemented and administered by human beings, some of whom make mistakes and some of whom will sometimes do bad things, and that we should be used to that. And then I think part of what we do is try and help each branch of government to stay within the lines in terms of what the scope of their own powers are.
It seems like a lot of our conversation today and this set of issues and problems comes about precisely because the representative branch that would be the primary force against the executive branch overstepping its power has gone moribund. And not only that, when the parties are the same, the majority party of Congress with the president, then they tend to let themselves be defined by the president explicitly. And
very much so.
If they don't step in, then we get state attorneys general suing. We get aggressive district courts. We get all this sort of interplay back and forth. That is arguably much more problematic.
Very much so. So a lot of the cases that have been coming up to the Supreme Court in these in the cases where the Trump administration has sought relief have involved things like reductions in force at federal agencies or restructuring agencies, and whether the Trump administration is going to spend money or not spend money, things like that. And in those cases, the people suing will be like, some employees or a union. And rather than suing for the back pay or benefits or what have you of employees that claim they were unlawfully discharged, they're trying to vindicate their view of Congress's plan or what Congress had intended or provided for in various statutes. And what's missing, as you said, from this picture is Congress, right? If Congress created the Department of Education and Congress still wants the Department of Education to perform a variety of functions, Congress should be the primary actor policing whether the executive branch is in fact following Congress's instructions. And if it's not, that shouldn't create a vacuum that courts just fill. But you're absolutely correct that so much of this is a consequence of the legislature not playing a proper role, not protecting its own prerogatives. Some folks have pointed out the separation of parties seems to have replaced the separation of powers in certain respects, right? So while we expect the president's party and Congress to generally be protective of a president of their party, we would hope at the same time they are also protective of legislative prerogative, and that there are things like spending, like the sorts of programs that Congress has created, the Senate's role in appointments and the like, that we would like to think Congress is jealous of and doesn't allow the executive to transgress. And its failure to do so, its failure to update statutes, its failure to provide more clear directives about how to implement certain programs gives the executive branch more slack to work with, and then leads to some of these conflicts that people try and resolve in court. But the answer here, as in so many areas, would be for Article 1 to resume its place, resume its proper place.
Rightful phrase, as noted in the Constitution.
That's right.
John, thank you so much for joining us today, this episode of Civitas Conversations. We appreciate it.
My pleasure.